Your conference is being recorded. Hello, good evening, and welcome to the American Association of University Women's Legal Advocacy Fund Supreme Court Review Call for the October 2018 Supreme Court term. I'm Kate Nielsen, AAUW State Policy Counsel, and a lawyer on staff working with the Legal Advocacy Fund, or LAF. LAF helps to fund cases challenging sex discrimination in education and the workplace, and joins cases as amici or a friend of the court. The goal of the program is to provide support for sex discrimination cases in order to develop good case law and establish new legal precedent for gender discrimination cases. While the LAF program focuses on cases at multiple levels in the judicial system, tonight we'll be focusing on our highest court, the U.S. Supreme Court. We're going to discuss the decisions that the Supreme Court reached or decided not to hear during this past term, focusing on the issues impacting AAUW core values. Tonight, our discussion will feature Deb Bagans, our resident expert and Senior Vice President of Public Policy and Research here at AAUW. Together, Deb and I will talk about some of the major decisions and non-decisions that occurred over the last 10 months. Before we get started, I want to make a few housekeeping announcements. Because of the volume of participants on this call, the call will be in lecture-only mode, so you will be on mute and not have the ability to ask live questions. However, if you have questions, please email them to laf@aauw.org. That's laf@aauw.org. And if time permits, we will try to address them at the end of the presentation. If you have branch members you would like to share this presentation with at a later date, you can. It's being recorded and will be archived on our website. Now I'd like to introduce Deb, who is going to start by talking a bit about AAUW's strategic approach to advocacy and the impact of the cases we work on through the LAF program. Deb?
Thanks, Kate, and thank you all so much for calling in and listening tonight. One of the things we've done over the last year and a half in this department in combining our policy work and our legal work is to make sure that our advocacy choices reflect the need for change in both the legislative and legal worlds. So in other words, we know we need to strengthen the Equal Pay Act of 1963. So we're trying to pass the Paycheck Fairness Act, which would update that law. But in the meantime, we need to continue to try to get favorable decisions interpreting critical parts of the Equal Pay Act as it exists now to make it as robust as possible through judicial decisions. The work does not exist in a vacuum, and for all the cases we select, it reflects a larger consideration of the larger policies we're fighting for.
Great, thanks, Deb. With that introduction, let's get to the meat of the call. Tonight we're going to discuss cases in three categories, focusing primarily on employment and education protections, health care and reproductive rights, and voting rights. Let's dive into some of these cases. We're going to start with a case that many people may already be familiar with. If you are a longtime AAUW member and supporter, you've certainly heard the name Aileen Rizzo. Her case, Yovino v. Rizzo, is one about equal pay, challenging the use of prior salary to set wages. Let me quickly review the facts of this case. Aileen Rizzo worked as a math consultant for the Fresno County Office of Education in Fresno, California. She found out that she was being paid less than a male colleague with less experience and seniority. This was because the office based new employees' salaries on one factor, the employer's prior salary. Rizzo sued the county, claiming that this pay policy violated the Equal Pay Act, Title VII, and California's sex discrimination statutes. The county argued that prior salary was a viable explanation for different salaries between men and women, as the Equal Pay Act allows for pay disparities if they are based on a, quote, factor other than sex, unquote. Rizzo brought her case all the way up to the Ninth Circuit, where the full court ultimately heard the case. On April 9, 2018, which happened to be the day before Equal Pay Day, the court held that prior salary cannot be considered a, quote, factor other than sex, unquote, under the Equal Pay Act because of the potential for previous salaries to have been discriminatory. This means employers in the Ninth Circuit cannot use prior salary as a justification or defense for paying men and women differently for the same work. This decision was seen as a major victory, particularly because the opinion offered a forceful explanation of why salary history was a vehicle for perpetuating discrimination. Unsurprisingly, Fresno County did not like it and appealed it to the Supreme Court. I'm now going to turn it over to Deb to provide the update and explain where things went from there.
Thanks, Kate. This is one of these strange fluke of fate cases. So unfortunately, there is one more important fact that is relevant to Rizzo's story at the Ninth Circuit, which I need to talk about before we can explain what happened at the Supreme Court. So on March 29, 2018, less than 2 weeks before the opinion in Rizzo's case was published by the Ninth Circuit, the author of that opinion, Judge Reinhardt, passed away. Judge Reinhardt was alive to take a vote on the case and author the opinion, but died before it was ultimately issued by the court. As a result, when Fresno County appealed, they also asked the Supreme Court specifically to consider this factor, and it was at the crux of what the court ruled. So on February 25th, 2019, this past February, the Supreme Court they vacated and remanded the Ninth Circuit's decision, which means that they determined that the Ninth Circuit decision was flawed and must be sent back to the appellate court for additional review. The court arrived at this conclusion without ever reaching the merits of Rizzo's equal pay claim or making a decision about prior salary history being a defense for an employer in an Equal Pay Act case. They focused solely on the issue of whether a federal court can count the vote of a judge who dies before the decision is issued. Although the other 5 living Ninth Circuit judges concurred with Judge Reinhardt, they did so for different reasons. Additionally, opinions can theoretically change up until the moment of publication. So the upshot was that Judge Reinhardt's vote made a difference to the ultimate conclusion, so the Supreme Court had to determine whether it was appropriate for his opinion and vote to stand. And they determined that it was not. In returning the case to the Ninth Circuit, the Supreme Court stated that because Judge Reinhardt was no longer a judge at the time when the decision in the case was filed, the Ninth Circuit made a mistake in counting him as a member of the majority. The Supreme Court concluded that, quote, the practice effectively allowed a deceased judge to exercise the judicial power of the United States after his death, but judges are appointed for life, not for an eternity, end quote. That's the court trying to be a little bit funny. As a result, the court sent the case back to the Ninth Circuit without addressing the equal pay question before them, so meaning that they vacated it, so it's as if the victory never happened. Now we will have to wait to hear how the new full panel of the Ninth Circuit will deal with the issue. We know that Judge Carlos Bay, President George W. Bush appointee, has been drawn as the replacement for Judge Reinhardt. So in the meantime, AAUW will continue to support Aileen's case as it continues to work its way through the process. One can imagine if the new Ninth Circuit panel rules the same way, giving her a victory, her employer may choose to appeal it again to the Supreme Court, this time on the merits. So we'll keep an eye on this because it's very possible that this case is far from over.
Great. Thanks, Deb. I'll look forward to hearing more and certainly hope that Judge Reinhardt's logic stands in the end. From here, let's talk about a different aspect of employment law, arbitration, specifically class action arbitration. The case we're going to discuss is Lamps Plus, Inc. versus Varela. We covered this case in last fall's Supreme Court preview call, and now the court has decided the case. The pre-dispute mandatory arbitration process is often a problematic one, and something that AAUW has long advocated against. Arbitration is often secretive and expensive, it lacks due process and the full range of rights available in court, and silences employees' voices because of the disincentives to moving forward with a claim. In fact, studies show that workers are both less likely to go forward with and less likely to win in mandatory arbitration. So with that background in mind, let me tell you about the facts of this particular case. Frank Varela, an employee of the company Lamps Plus, had signed an arbitration agreement as a condition of his employment. The agreement forced employees to waive their right to sue their employer in court and instead bring complaints through private arbitration. This became relevant when Frank Varela filed a class action lawsuit against Lamps Plus after the company released personal information about its employees in response to a phishing scam. Lamps Plus responded to the lawsuit by asking the district court to make him pursue his claims through individual arbitration, given the previous agreement that he signed. The district court agreed that he had to proceed with arbitration, but said that he could engage in class action arbitration, since the agreement was ambiguous. A divided Ninth Circuit panel affirmed this decision. Lamps Plus appealed to the Supreme Court, arguing that the Federal Arbitration Act, or FAA, requires that both parties have to affirmatively consent to class arbitration. Previous case law establishes that a court may not force class arbitration when agreement is, quote, silent on its availability. But this case looks at whether the FAA bars class arbitration when agreement is, quote, ambiguous about it. Deb, what does the Supreme Court have to say about this question?
So in this case, the Supreme Court disagreed with the Ninth Circuit and said that ambiguous arbitration agreements do not permit individuals to proceed as a class. So individuals must proceed on their own unless the arbitration agreement explicitly allows for class arbitration. This means Lamps Plus won its challenge. The case was decided by a 5-4 vote with Justice Roberts authoring the majority opinion. Of note is the fact that the court said arbitration is a matter of consent, not coercion. Unfortunately, this ignores the fact that the contract was required as a condition of gaining employment. So this is a difficult case because pre-dispute arbitration is a problematic practice overall. So we're disappointed by the outcome because we support class proceedings. They make it easier to challenge systemic issues within the workplace. It's easier to band together to challenge a practice for all workers. But even if the plaintiff won and was able to proceed through class arbitration, he still would have been engaged in the mandatory pre-dispute arbitration process, which forced him to waive his right to proceed in court at the outset. That being said, we were hoping that the court would reach a different outcome that would have allowed a more expansive view permitting class arbitration, even when not explicitly stated in an employment agreement. So this decision is a victory for employers seeking to arbitrate workplace claims on an individual basis. So unless it is crystal clear that the parties agreed to arbitrate on a class action basis, it's going to be easy to avoid class procedures, especially because employers and businesses write the agreements in the first place. So it's really in their hands, and undoubtedly this will result in more pre-dispute mandatory arbitration clauses that make employees waive class proceedings. So despite this disappointing setback, AAUW has advocated and will continue to advocate that employees should not be forced to waive their rights to pursue legal action as a term of employment. In fact, we're working on several pieces of legislation on that point right now. All employees must have the ability to bring class actions in court in order to challenge systemic issues within the workplace.
Thanks, Deb. Although I'm disappointed to hear that update. Let's take a different angle of employment law and talk about anti-discrimination, specifically in the LGBT community. We're going to start with a set of 3 cases: Harris Funeral Homes v. EEOC, Altitude Express v. Zarda, and Bostock v. Clayton County, Georgia. This group of cases gets at the heart of the definition of sex by addressing Title VII and workplace discrimination. These cases collectively address whether the sex-based employment protections of Title VII of the Civil Rights Act of 1964 include discrimination based on sexual orientation and transgender status. Even though these cases weren't heard this term, we wanted to mention them since the court granted cert and will be hearing them together. Oral arguments are set for October 8th. We expect them to be decided by June 2020 at the latest. Let me briefly tell you about the facts of these cases. Amy Stevens, a transgender woman, was fired after she came out to her employer, the owner of Harris Funeral Homes, as transgender and told him that she planned to start presenting as a woman consistent with her gender identity. Stevens filed a complaint with the EEOC, claiming that her firing was the result of unlawful sex discrimination. The EEOC agreed and filed a suit against Harris Funeral Homes for violating Title VII, taking the position that discrimination on the basis of gender identity was covered by the prohibition on sex discrimination. This case went up to the Sixth Circuit, where the court agreed with the EEOC. That court held that the funeral home had violated Title VII because firing someone for transitioning is inherently based on the person's sex and is an act of sex stereotyping. The Harris Funeral Homes case could determine whether Title VII's prohibition on discrimination because of sex includes discrimination based on an individual's gender identity. In the other two cases, Bostock and Zarda, the Supreme Court will take on the question of whether Title VII's definition of sex includes protection for sexual orientation. Bostock was fired from his job as a county child welfare services coordinator when his employer learned that he was gay. Similarly, Zarda was a skydiving instructor who was fired after disclosing his sexual orientation. Both plaintiffs brought cases claiming that their employers had violated Title VII by firing them for their sexual orientation. However, the appeals courts in the two cases handed down conflicting opinions. In February 2018, citing evolving legal doctrines, the Second Circuit in Zarda held that discrimination based on sexual orientation violates Title VII. But in May 2018, the 11th Circuit in Bostock said Title VII's definition of sex does not include sexual orientation, relying on recently affirmed 11th Circuit precedent. These conflicting holdings are known as a circuit split, and one of the Supreme Court's main criteria for hearing cases is to resolve circuit splits. The Supreme Court decided to hear these cases together, given that they hinge on the same question. Does Title VII, which prohibits employment discrimination, quote, because of sex, unquote, encompass discrimination based on an individual's sexual orientation or gender identity? Deb, what do you think about these cases and how the court might fall on the issue?
Great. So let me start by saying that I really had the privilege of working on the Zarda case and the Harris Funeral Home case when I was at the EEOC, the job I had before joining AAUW. I also worked on a groundbreaking case that set out the legal theory of the cases that were later used in court called Baldwin versus Department of Transportation. And that's where the EEOC in depth articulated that sex discrimination under Title VII included protections for sexual orientation and gender identity. So since 1964, the legal framework for evaluating Title VII claims has evolved substantially in the courts. Title VII's prohibition on sex discrimination applies to any practice in which sex is a motivating factor. As Justice Scalia observed in the 1998 case On Call versus Sundowner, which found that same-sex sexual harassment actionable under Title VII, he said that, quote, statutory prohibitions often go beyond the principal evil to cover reasonable comparable evils, end quote. In other words, sometimes the laws evolve past concepts that were contemplated at their drafting. It's surprising that this came from Justice Scalia, but it's very important in this area. But despite this evolution, recent rollbacks of LGBT rights by this administration paint a very troubling picture of where those rights stand. And of course, I'm nervous about the court's take on this set of cases. While the EEOC, which is an independent agency, continues to argue for now that Title VII protects LGBT workers, the Trump Department of Justice is now asserting the opposite in court. I also want to mention that there are a number of different amicus briefs that support this interpretation that the employment protections of Title VII include discrimination based on sexual orientation and transgender status. The amici collectively urge the court, the Supreme Court, to hold that Title VII's prohibition encompasses protections for LGBT workers. Each of these briefs supports different elements of the merits. We joined one, and the one we signed on to argues that allowing employers to engage in sex discrimination tied to sexual orientation or gender identity would actually undermine the ability of all employees who do not conform to sex stereotypes, not only those whom are LGBT. It would undermine their ability to participate in our workplaces and in our economy. So no limitation based on sexual orientation or gender identity should be imported into Title VII's long-standing protections against discrimination based on sex stereotyping. In other words, not all people conform to traditional male and female stereotypes, and this is regardless of their sexual orientation or gender identity. These cases have the potential to have a huge impact on the future of workplace discrimination law, and will go to the heart of Title VII and the definition of sex in our civil rights laws, potentially beyond Title VII. I can only hope that a court that has allowed the freedom to marry without discrimination will allow the freedom to work without discrimination. So we're going to look forward with some trepidation to learning the outcome in the coming year.
All righty. Exciting stuff. Thank you, Deb. Let's continue our discussion of anti-discrimination cases, but shift to the educational setting. Doe v. Boyertown pertains to discrimination against transgender students. By way of background, AAUW believes allowing students to use the bathrooms and locker rooms that best match their gender identity is consistent with Title IX and its prohibition on sex discrimination in education. This case began when a group of cisgender students, that is, students whose gender identity corresponds to their sex at birth, challenged a Pennsylvania school district's policy of allowing transgender students to use the facilities that best match their gender identity. They argued that the policy violated cisgender students' right to privacy and constituted sexual harassment under Title IX. AAUW signed on to an amicus brief supporting the school district in their defense of their policy to the Third Circuit. The Third Circuit agreed with us and rejected the claims from the cisgender students. The plaintiffs then appealed to the Supreme Court. The question before the court was whether or not this policy indeed violated the right to privacy of the cisgender students who challenged it, or Title IX's prohibition on sex discrimination. Inherent to this discussion is what, quote, on the basis of sex, unquote, means and includes. So what does the Supreme Court have to say then?
Well, the Supreme Court ultimately declined to hear Doe versus Boyertown. In Supreme Court parlance, they denied certiorari, or denied cert. As a result, the court's decision not to hear the case then upholds the ruling from the Third Circuit below in favor of the transgender inclusive bathroom policy. This allows Boyertown's policies supporting transgender students to continue, which is a very important victory. It also supports an accurate reading of Title IX that AAUW supports, including a definition of sex that encompasses both gender identity and sexual orientation. The Third Circuit said that sex had been narrowly limited to a person's anatomy under Title VII. And so, I'm sorry, let me try it again. The Third Circuit had said that sex had not been narrowly limited to a person's anatomy under Title VII, nor by analogy is it limited under Title IX, which is great. And that's also how you can see how these statutes often work together and decisions borrow from each other. The further reasoning behind the court's support for the school district's policy and rejection of the Title IX claims brought by the cisgender students is twofold. First, the school district's policy did not discriminate on the basis of sex because it actually applied equally to all students. So it applied to cisgender male and cisgender female, as well as transgender male and transgender female students. So it applied to everyone. Second, there was no conduct identified that was sufficiently serious to constitute Title IX harassment. The mere presence of a transgender student in a locker room is, of course, not objectively offensive to a reasonable person, given the safeguards of the school's policies. Schools can and should provide privacy protections or private bathrooms or changing areas for any student who requests it. But no student has the right to demand that transgender students be segregated from their peers. Transgender students need to have access to facilities that align with their gender identities. The students who challenged the policy incorrectly identified transgender students as being of the opposite sex in the facilities that they were using, and then alleged nothing other than the fact that those students were doing what they are supposed to do in a locker room and bathroom. None of the behavior amounts to a sexually hostile environment in violation of Title IX, nor does it subject the students who challenge the policy to any harm. Their allegations are speculative and a discriminatory attempt to impose stereotypical gender norms on the entire school district, directly harming anyone who does not conform to those stereotypes, including transgender students. So I'll leave you with a quote from Aiden DiStefano, a recent graduate of Boyertown High School who is transgender and who could say it better than I ever could. He said this in following response to the announcement that the Supreme Court declined to hear the case. He said, "By the time I graduated high school, I was using the boys' bathroom and participating on the boys' cross-country team. I felt like I belonged and had the confidence I needed to continue with my education. I'm glad the Supreme Court is allowing schools like mine to continue supporting transgender students." I really think that beautifully sums up this case.
That's wonderful. Thanks, Deb, and nice to end our employment and education section on a high note, so thank you. With that, I'm going to shift gears to talk about healthcare, where it seems that there are endless battles about rights and access these days. The first case we're going to address is Box v. Planned Parenthood of Indiana and Kentucky, and this pertains to limitations on abortion access. The case challenged two provisions of Indiana state law relating to abortion. One of those required fetal tissue from an abortion or miscarriage to be buried or cremated. The other made it a crime to provide an abortion based on a particular characteristic, like sex, race, or disability. Planned Parenthood challenged these laws as unconstitutional. The Seventh Circuit agreed, finding both provisions to be unconstitutional. There are different standards that courts can use to review questions of constitutionality. Some are more stringent than others. In the case of the disposal of fetal tissue, there is no fundamental right at stake, so the Seventh Circuit used a rational basis review standard. That means that in order to be upheld in court, the law would have to have a rational relationship to a legitimate state interest. But the court didn't find such a relationship, and they struck down the law. Regarding abortions based on a particular characteristic, the Seventh Circuit found that the law violated well-established Supreme Court precedent, holding that a woman may terminate her pregnancy prior to viability, and that the state may not prohibit a woman from exercising that right for any reason. The state appealed these determinations to the Supreme Court. Deb, can you tell us what happened from there?
Yes. So in this case, the Supreme Court actually didn't hold arguments to consider it. Instead, they issued what's called a per curiam opinion, meaning by the court, and indicating that the justices acted collectively with no single justice authoring the opinion. Typically, per curiam opinions are issued when the opinions are short and viewed as relatively non-controversial, although once I finish the summary, one could really argue if this is a non-controversial case. The outcome is that the Supreme Court disagreed with the Seventh Circuit on their determination on the fetal tissue law and let the Seventh Circuit opinion stand on the issue of selective abortion. So it was a split decision. With regard to the disposal of fetal tissue, the Supreme Court reversed the Seventh Circuit, allowing the Indiana law to stand. So the Supreme Court let remain in place the mandate that the, quote, remains, unquote, of an abortion or miscarriage be buried or cremated. This is very disappointing, as the restriction has nothing to do with medical care and instead will add, and I think purposefully, an emotional burden, shame, and stigma for women and families in this situation. On the second question regarding the barring of selective abortions, the Supreme Court declined to take up the issue because there was, because there was no disagreement yet from the courts of appeals on the issues. As a result, the law banning selective abortions remained struck down. This means that the court could take up the issue again when there is a circuit split, and it leaves open the possibility that they would find this type of law constitutional in the future. We just don't know. Ruth Bader Ginsburg and Justices Ruth Bader Ginsburg and Sonia Sotomayor said they would have both allowed the lower court's rejections of the law stay in place, which shows that the per curiam decision was not without controversy. And also of note, Justice Thomas wrote an alarming 20-page concurrence linking abortion to the eugenics policy popular in the 19th and 20th centuries. So as I've said, while this ruling is limited, it's still troubling. There is a current trend of state laws passing that are designed to limit access to abortion care, either virtually outlawing the medical procedure altogether or making it out of reach for large swaths of the population. And because these troubling laws keep passing and being challenged, there are a number of cases pending that have been designed to become a challenge before the Supreme Court, such as the more expansive bans on abortions as early as 6 weeks gestation. It's going to take some time for the most restrictive bans to work their way through the lower courts, so we will keep an eye on these, weighing in, opposing them in litigation and in our legislative efforts.
All right, thanks, Deb. Let's talk about another set of cases that address access to abortion as well, but this time vis-a-vis Medicaid funding. We discussed one, Anderson v. Planned Parenthood of Kansas and Mid-Missouri, on last year's Supreme Court preview call. Now we'll also bring in a similar case, Gee v. Planned Parenthood of Gulf Coast. On last year's call, we previewed Anderson. This case, along with Gee, is about whether individual Medicaid recipients have a private right of action. To understand how these cases play out, we need to know that Medicaid has a provision called the Free Choice of Provider provision that guarantees that Medicaid recipients can obtain medical care from a qualified and willing medical provider of their choice. These cases ask whether Medicaid patients have a private right of action to challenge a state's determination of which entities are qualified providers. The providers at issue in this case were Planned Parenthood affiliates, and the reason they were targeted, but ultimately this case isn't directly about abortion rights. It's about the ability for individuals to sue when a state terminates a Medicaid provider. In Anderson, Kansas sent notices of decisions to terminate its Medicaid contracts with two Planned Parenthood affiliates, Planned Parenthood of Kansas and Mid-Missouri, and Planned Parenthood of the St. Louis region. The notices cited non-medical concerns, like billing and solid waste inspection concerns, as the justification for the termination. Similarly, in Gee, Louisiana notified a Planned Parenthood affiliate that it would be terminating the provider's Medicaid agreements. The notification offered no rationale, but the governor at the time released a press release the same day stating that the state was terminating the contract, quote, because Planned Parenthood does not represent the values of the state of Louisiana in regards to respecting human life, unquote. In both cases, a group of individuals and Planned Parenthood affiliates sued. The 10th and 5th Circuits found largely in favor of them, holding that the Medicaid Act does in fact create a private right of action, and prohibiting the state from following through with the contract termination. However, the 8th Circuit viewed the issue differently in an earlier decision, Does v. Gillespie, which means there's technically a split with the 5th and 10th Circuits, since Does v. Gillespie held that the law doesn't allow Medicaid recipients to sue the state to enforce the law's provision. So Deb, what's going on here?
So, despite the circuit split, this is yet another case where the Supreme Court denied cert for the cases before them, Anderson and Gee. So thus deciding not to hear the cases and let the lower court's ruling stand. That is, agreeing that the plaintiffs do have a private right of action under the Medicaid Act. This is a momentary win. At least in the majority of circuits, patients have a right to sue and with that obtain health care from the qualified provider of their choosing. As such, plaintiffs have the ability to sue when the states act to deny funds to certain health care providers for reasons unrelated to the provider's competence and the quality of the health care it provides. This is good. This is an important decision, but while it is good, it is limited, of course. In these cases, the states terminated their agreements with a provider for little or no legitimate reasons. So we would say that they were pretextual reasons for cancellation. It's still possible. A similar challenge could be brought with a better rationale for the termination of a provider agreement, which could be used as a way to go after providers that conduct abortions or frankly are just politically unpopular in the state. That's what we felt was going on in these cases. And in fact, the groundwork for this has been laid given that Justices Thomas, Alito, and Gorsuch vigorously dissented from the decision not to hear these cases. They really thought they should have been taken up by the court.
Okay, that's interesting. Thanks, Deb. In our third and final grouping of cases, let's quickly discuss two cases that were decided by the Supreme Court at the end of the June term that pertain to voting rights and redistricting. In Rucho v. Common Cause and Lamone v. Benefec, the court looked at partisan gerrymandering, that is, the practice of drawing electoral district lines to benefit one political party. The Rucho case involved a challenge to North Carolina's Republican-drawn congressional map on the grounds it was the product of partisan gerrymandering. Benefec challenged the map that Maryland Democrats drew on the same grounds. In both cases, the district court agreed that the state map was the product of unconstitutional partisan gerrymandering. North Carolina Republicans and the Maryland Attorney General respectively appealed to the Supreme Court, and the court decided to consolidate the cases. There were several questions at issue in these cases, but the Supreme Court ultimately focused on one question. Do federal courts, including the Supreme Court, have the ability to rule on partisan gerrymandering claims? Deb, what did they conclude?
So before I get to the conclusion, the reason I wanted to quickly touch on these cases is because the right to vote is preservative of all other rights we have discussed on this call. So, in other words, if you care about equal pay, LGBT rights, and health care, ensuring that you have a free and unfettered right to cast your ballot for the policymakers or policies that uphold those values and have your vote count is critical to ensuring all of those rights. So we must begin with voting rights. So getting to the heart of the decision. So in a 5-4 decision with Justice Roberts writing for the majority, the court held that partisan gerrymandering claims present political questions which are beyond the reach of the federal courts, meaning the Supreme Court will not weigh in and help fix politically gerrymandered maps. This is a loss. Gerrymandering poses serious problems for our democracy. The way lines are drawn affects who is elected. So by packing voters who favor one party into the fewest districts possible, known as packing, or spreading those same voters out over many districts to guarantee that those voters hold minimal influence, the practice known as cracking, gerrymandering works against fair representation and can lead to undue influence from one political party. Either of these scenarios leads to voters in the aggregate not being represented proportionally in the state. For example, gerrymandered maps can be drawn, as I mentioned, to pack all of one party into fewer districts, or can be drawn trying to spread them out across many different districts so they don't have enough voters in each district to elect the candidate of their choice. In addition, elections in those districts may become uncontested or lopsided over time, and states where gerrymandering is widespread, legislatures are able to push through policies that fail to reflect voters' values or needs. This all adds up to legislators drawing maps that allow them to choose their voters rather than enabling voters to choose their representatives, a reversal that is just the basic undermining of the concept of fair representation. So because the Supreme Court said that they won't help, it's up to state legislators, legislatures, or Congress to make relevant changes. But as I've said, because many legislatures are already gerrymandered and state legislators created the problem in the first place, we know this may be an uphill battle. And so, sorry to end on a bad note, but there's no way to sugarcoat it. This is really a loss.
Disappointing, to say the least. But we do have some better news to report out in the last case we're going to discuss tonight. Department of Commerce v. New York. This is the case about the citizenship question on the 2020 census. I'm sure most, if not all of you, have heard about the Trump administration's attempt to add a question about citizenship to the 2020 census. In our policy work, AAUW joined hundreds of organizations in opposing the addition of this question, and we support the goal of conducting a fair and accurate census. As such, we want to touch on this case and give a brief discussion of it. This all began when Secretary of Commerce Wilbur Ross announced that he decided to add a question about citizenship on the 2020 census. In response, two cases were brought. One by a group of states, cities, and counties, which challenged the inclusion of the citizenship question on the census. They claimed that it violated the Enumeration Clause, also known as the Census Clause, of the Constitution and the Administrative Procedure Act, or the APA. The other case was brought by NGOs working with immigrant and minority communities. That case made an argument regarding equal protection. The district court consolidated the two cases, dismissing the Enumeration Clause claim, but considering both the statutory, that is the APA, and the equal protection claims. With regard to the statutory claim, the district court ruled that the Secretary violated certain provisions of the APA. He ignored and violated aspects of the statute, failed to consider many important aspects of the problem, cherry-picked or misconstrued evidence in the record, acted irrationally in light of the evidence, and failed to justify significant departures from past policies and practices. Basically, a lot of problems, making his decision arbitrary and capricious, and therefore in violation of the APA. However, on the equal protection claim, the NGOs failed to show that the Secretary was motivated by discrimination. As a result, the district court found that there was no equal protection violation. So what this all means is that the district court determined that while Secretary Ross did not violate the Constitution, he did violate the APA. As such, the district court enjoined him from adding the citizenship question to the census unless he went back and complied with the statute by curing the legal errors the court identified. The government appealed to the Second Circuit, but also filed for cert with the Supreme Court, given the timeline of the issue. The Supreme Court granted cert. Deb, do you want to take it from here?
Yeah, so in another 5-4 opinion, with Justice Roberts joining the liberals on the court, the Supreme Court blocked the citizenship question from being added to the 2020 census for now and sent the case back to the agency to provide additional justifications for why the administration took this action. So this is a win, as I said, for now, but we have to stay on guard. The court did not say that the Commerce Department can never include the question, just that it couldn't be done in this way, finding that the department's action didn't correspond to what the record revealed about its priorities and decision-making process. And I'm putting that nicely. Justice Roberts explained that administrative law is, quote, meant to ensure that agencies offer genuine justifications for important decisions, reasons that can be scrutinized by courts and the interested public. Accepting contrived reasons would defeat the purpose of the enterprise. If judicial review is to be more than an empty ritual, it must demand something better than the explanation offered for the action taken in this case, unquote. Basically, this leaves the door open for the administration to present the evidence for its decision to include the citizenship question in a different way that would meet muster, if it can. So this is not the end of the story. Things continue to change. Just since we started to pull together information to brief you on all of this, the landscape has already changed. So after a few more threats and false starts from the administration, the government did begin printing the census questionnaire, and it does not contain the citizenship question. That being said, the administration announced its intention to attempt to collect data on citizenship by going through other agencies or exerting other executive action, but exactly when or how that will happen has not at all been made clear. Initially, the Census Bureau estimated that 6.5 million people would not respond if the citizenship question was included. Since the census is used to apportion congressional seats, conduct redistricting, and inform the distribution of money, federal money for social services, undercounting throws off these processes and needed services for people. And the undercount would primarily impact communities with immigrant populations and people of color, meaning less representation and less money. So this is a victory, but I feel like I'm ending a lot of the discussions this way. We certainly worry remains that this administration is pushing people into the shadows and scaring some communities of people away from answering the census, as well as seeking other necessary services generally.
Okay, great. I'm glad we're at least potentially ending on a win, sort of, for now.
Yes.
But thanks for that analysis, Deb. Do you have any overarching thoughts about the court this term or what this all means for our rights going forward that you want to share with us?
So for AAUW, the court didn't address huge blockbusters this term, with the exception, of course, of gerrymandering and census issues. For AAUW and our partners, winning this term, what winning looked like was really not having our cases heard and letting lower court rulings stand. We know that Chief Justice Roberts cares deeply about the reputation of the court, and sometimes I'm reading tea leaves. We're all speculating here, but I do think that he's trying to make sure that the court is not seen as a hyper-politicized body. There's only so much you can avoid that, but I do think that appears to be a motivating force. So as such, and you could hear from the descriptions, he exercised avoidance on some of the hot topics or some of the questions by either denying cert or answering questions very, very narrowly. But we do know that next year there will be big cases teed up, so we'll see how that philosophy plays out next year.
Interesting. Thanks, Deb. All right. That concludes the meat of our call, but we'd love to take any questions that you all have. As I said at the beginning, we're keeping the lines on mute because of the high volume of callers, but we'd love to take any questions that you have via email. As a reminder, if you have a question, please email it to laf@aauw.org. That's laf@aauw.org. And we'll try and get through as many of these as we have time for, or as they come in. We did get one question earlier today that I'm going to sort of paraphrase and package with a little bit some other concepts to get Deb to give us a robust answer on this. Fair warning for you, Deb.
Okay.
So wondering, given the new makeup of the court and what you talked about earlier in terms of the health care cases, and as you just referenced, reading tea leaves,
yeah.
Just wondering what the likelihood is that the court's going to overturn Roe v. Wade, or generally further address access to reproductive rights, both in this upcoming session and longer term. What's your prognostication on that?
So I don't know if sarcasm reads over the phone, but I'm glad we're starting with a really easy question, so thank you. Will the court overturn Roe versus Wade? This is the question people have been asking basically since the decision was originally decided, and I wish I did have the answer. All I can do is guess. I think on the last two calls I challenged. I said, let's see how I do, and so I'm going to ask the folks calling in tonight, let's see how I do next year. So looking at all the data points, so given how the court handled abortion-related cases in the last year, to me, and this is, of course, speculative, it seems unlikely that the court will outright overturn Roe in one fell swoop, in one decision in the near future. And remember, even if Roe versus Wade were overturned at the federal level, likely what it would look like, it would return it to the states. It would be like what it was before 1973. Some states would, some states wouldn't. That's what an overturning could look like. But I don't know that they're going to do that in one fell swoop. So, of course, I don't know, but I hope that's the case. Some commentators think that, as I mentioned before, Chief Justice Roberts is concerned about the public perception of the court and is concerned that a high-profile decision on such a divisive issue would give the appearance of partisanship. You know, obviously they've not avoided that universally, but that appears to be a thread that you can see in some of these cases. I think Roberts' desire to stay out of this political issue in some ways is probably heightened, given that the decision would be happening months before a presidential election, or maybe I'm just being hopeful. But to me, and I don't know if this is good news or not, to me it seems more likely that the justices would issue narrow rulings, as they have been doing, chipping away at abortion access. So I think that's probably the balance as I see it, but I also want to be very, very clear that even if it is a slow chipping away, it's vitally important to remember that when you restrict access, for some women this is tantamount to denying the right in its entirety anyway. So if you can't travel to another state, or if you need financial assistance, or if you've got to have different types of assistance, the right to an abortion may exist on paper, but not in reality for you. So that's why we really have to stay vigilant in either outcome. It's also important to remember that the proliferation of these extreme state laws, the people who write these and get them passed know they are unconstitutional, I believe, as written, or many may realize that, but they are specifically intended to tee up a case through which the court could overturn precedent and say they are no longer unconstitutional and would then effectively overturn Roe. There will be a lot of pressure on Roberts to take up one of those cases, and we'll have to wait and see what happens and continue our advocacy for choice.
All right. Thanks, Deb. I can't say I love your answer, but I also don't disagree with it. It's troubling and a little scary, but thank you for that. As another reminder, if you have a question, please email laf@aauw.org, and we'll try and get to as many as we can. We have one more here in the queue. So this is talking about the Title VII cases, the LGBT cases that we talked about a little earlier, and wondering what happens if in those cases the court decides that sex is defined only as biological.
Okay, so no one wants to give me an easy question. All right, so we have what happens if the court overturns Roe versus Wade, and what if the court takes the bait and defines sex as only biological. Okay, so that would be a huge setback and have a major impact on our work. It would prevent us, let me preface that though by saying the words really matter in what a decision would look like. So I'm sort of doing this very broad strokes. The wordings of decisions matter. It matters which statutes they reach. All of that matters. But let's just say generally, it would prevent us from using Title VII or potentially more civil rights laws as they currently stand to protect LGBT people. Some agencies, perhaps this was more in the last administration than this administration, but some agencies and currently the EEOC have adopted the interpretation that sex discrimination laws, as written now, bar discrimination on the basis of sexual orientation and gender identity. But these agencies, might have to abandon that interpretation depending on the contours of the decision. As I said, the wording and what statutes the court ultimately reaches in the decision really matter. We are seeing a narrowing, as I said, of how they address questions. So, maybe even if it is a worst case scenario, it would be a narrow decision. But if they define sex as biological, it would be very, very messy to try to execute this because it is already entrenched in many of our federal circuits and in some of our agency interpretations. And it would be even more complicated if the court attacked the interpretation of Title VII as prohibiting discrimination based on sex stereotyping, which was an early way in the interpretation of Title VII to protect some LGBT workers under the law. For example, if the court said that sex stereotyping did not constitute sex-based harassment, which it has for a long time, what would this mean for women, cisgender women, straight women, who do not adhere to the narrow ideas of femininity in the workplace? Would there be some kind of proof needed of your sexual orientation to be covered? Again, this would be very, very messy. Or would there be some proof of your biology? I mean, it's just it would be a very difficult legal line to draw. So if the court did something like this, as has been the case with other narrow readings of civil rights statutes over time, we would need to try and fix this through federal legislation. This is, for example, what we did with Lilly Ledbetter when the Supreme Court made a terrible decision on Title VII. We went about redrafting elements of Title VII to fix it after the Lilly Ledbetter case, and that led to the Lilly Ledbetter Fair Pay Act. So if the court rules against LGBT inclusion in these cases, we will have to push even harder for passage of the Equality Act, and that is the federal bill that explicitly bans discrimination based on sexual orientation and gender identity in daily life, including employment and education and public accommodations and more. This is something AAUW strongly supports. The Equality Act has already passed the House, and AAUW is part of a robust coalition urging the Senate now to pass this much-needed legislation. I think this example is sort of ending where we began, which shows the integrated advocacy that we're trying to do here, where if you have a bad Supreme Court decision, we're going to then supersede the Supreme Court through federal uniform policy. I also will say if this happens, it's important to remember that the state laws that explicitly bar discrimination based on sexual orientation and gender identity would still be in effect unless the state legislatures acted. And I'm going to try to end here, which is, even though I'm saying all the worst case scenarios, because those are the questions I was given, I must remain hopeful that a court that would allow equality in marriage will allow equality at work. So that's where I'm going to try to end that question.
Thanks, Deb. I know we only have another minute or two, but we had one question come in that's going to be our last because it's just so perfect and a great way to cap off this call. So the last question is, what specific things can our teams and our branches do to support the issues that we care about? How can we take action and try and combat this? So, Deb, do you have a 1-minute concluding answer just to take us out on top with some hopeful suggestions
Very practical.
on how AAUW members can influence change?
Yes. So, of course, we have our 2-minute activist, which is our action network. It gives you timely information about legislation that may need support. So we would encourage people to sign up, go online to sign up for our 2-minute activist action network. Send that out to your friends, your branches, if people haven't already. That will allow you to take action in strategic ways. We have talked about the Equality Act. We've talked about the Paycheck Fairness Act. All of those. Please sign up for our newsletters, for Washington Update, for LAF Express, and for in the State House. Those will all help you stay informed. And then in those, we also have ways to take action of the moment, because those are timely communiques to our membership. We would ask that you meet with your elected officials at the state and federal level to talk about the issues that you care about. You can write letters to the editors and op-ed, use social media for these. Pay attention to the court decisions that are happening. Of course, we're AAUW always is hoping to have additional funds for our greatest needs. Greatest needs funding also helps fund LAF and policy and research, as well as all of the greatest needs at AAUW. So, of course, that's a way that's really, really helpful. And just continue to do the great work that you're doing. at all levels. So change is happening. We are working hard at the federal level. You can hear all of the things that we're up against. So don't give up on that. Keep up the drumbeat. But there is wonderful change happening at the state and local level, and so make sure that you get involved at all levels of our work. So that's a great last question, Kate.
Thanks, Deb. Perfect way to end. I hope that you all have enjoyed this review call for the October 2018 Supreme Court term. If you'd like to hear the presentation again or want to share it with others, a recording is going to be made available in a few weeks. I want to take the opportunity, Deb just mentioned this, but I want to encourage you to sign up for LAF Express and Washington Update, which is newsletters where you can stay apprised of our policy and legal advocacy efforts. Finally, I do want to thank Deb Vagans, AAUW's Senior Vice President of Public Policy and Research, for sharing her insight tonight, her knowledge and her expertise, and her take on these important cases in our current political landscape. Again, my name is Kate Nielsen, and I want to thank you for your time and attention during this call, and I hope you all have a wonderful night.